Appellant may proceed.
Good morning, Your Honor. May it please the court, my name is Bob Wilkins. I'm representing the plaintiffs in this case, Teresa Barton, who is the professional guardian for Ms. Penland, as well as Heather Carrison, who is the attorney representing the professional guardian. The case before the court today is one of, I think, very critical importance for those of us who practice in the area of guardianship law as well as homestead law. And the questions, I think, that need to be answered are sort of one at a time. The first one is, does a guardian have the authority by petitioning the court to essentially enter a transaction that waives the homestead exemption? I think clearly they do. The statute clearly allows the guardian with court approval to sell the homestead. That will terminate the homestead exemption. And I think equally accurately, in a case like this where they rent to a third party for a year's lease.
Is it the creditor the evidentiary burden of proof to demonstrate that the homestead has been abandoned by, I guess in essence in this case, the ward?
Well, I think the burden of proof to the exemption is the petitioner's burden. She claimed the exemption. The facts of the case...
But there's no dispute it was the homestead.
It was at least prior to the rental.
She was into at least in the ALF. I mean, for 31 years it was her home, and then
Correct.
She never came back during her 3 years in nursing home or ALF care before she passed.
I think the question is whether or not the guardian basically steps into the shoes of the ward in terms of that intention to abandon the homestead. And I think that's sort of the fundamental question. The court sort of had problems with the fact that Ms. Penland never abandoned her homestead. She never made the decision to do it. But I think the issue is, does the guardian speak for the ward in that regard? Because obviously the ward can't form an intent to abandon the homestead. She's incompetent.
But there wasn't actually an evidentiary hearing where the guardian testified, yes, it was my intent to abandon the homestead on behalf of, I guess, her mother.
Correct. This was done in the context, pretty typical, of a petition to determine homestead property filed in the probate proceeding while the guardianship was still open. So there was no testimony.
The issue is abandonment of homestead. That would be premised on the fact that there is a homestead already in place, but it was abandoned. So if abandonment is the issue, it wouldn't be on the property owner who has established homestead for some time to establish abandonment. It would be on the other party saying that there is no homestead, it was abandoned, right?
Well, I think that here in this case, there really aren't any facts in dispute. So in terms of the burdens of proof, I think the question is, were there sufficient facts to show abandonment?
About intent, whose intent is it? Is it the ward's intent, or is it the guardian's intent? And you said, well, the ward can't form an intent because the ward is incompetent.
Correct.
Just because a ward is incompetent doesn't necessarily mean that they can't speak their mind as to whether they want to have their homestead abandoned and form an intent as to that. That's kind of a factual issue, isn't it? As to whether they can form that intent?
I don't know that you could, I guess that goes beyond that. If the adjudication was a plenary adjudication, no, they can't form the intent. And that's what we had in this case. It was a plenary guardianship. So there's...
Well, all right, and so she was found mentally incompetent.
Yes. So that plenary guardianship basically says she doesn't have that capacity.
In instances of plenary guardianship, you're saying that the intent of the ward doesn't factor in, even if the trial court was to say, well, maybe she's incompetent for purposes of appointing a guardianship, plenary guardianship, but she's still lucid enough to form the intent about her homestead.
Well, keep in mind that this is a case where the ward was deceased, so you're not going to have anybody testifying as to the ward's intent, and if they did, it would be hearsay anyway. So...
But wasn't the property rented before?
It was.
Became deceased?
It was.
As far as the facts of the case, are there any other facts that you're relying on other than the rental of the property to support the abandonment issue?
That's the primary reason, and that's the critical question for this court, for all the practitioners in the state of Florida, because the practitioners in Florida have always believed that if you rent a person's homestead, that you have essentially established you don't have the ability to return to that property.
It seems like the issues framed for us by you is that as a matter of law, when the homestead of an incompetent ward is leased with consent of the court, that automatically is an abandonment of the homestead.
I think it is unless it's reestablished at a later date. In other words, if you abandon a homestead, you could clearly reestablish homestead status at some point.
Assuming the ward stays incompetent, or as in this case, passes.
Well, let's take, for example, if the ward in this case the lease had run out, and then the property is now occupied by a family member. I think that would basically resurrect the homestead status at that point, because at that point, the lease doesn't disqualify you from having that homestead exemption.
Well, in this case, did the lease expire on its own terms, and then 6 days later, the ward actually passed?
It did, and they continued to have a tenant.
We're still in the property.
Right, they still had a non-family member tenant in the property, so it wasn't a family member that was trying to occupy the property to resurrect, if you will, the homestead.
Expired, so...
The lease had expired.
And there had been no new actual written lease for the following year or whatever term entered into.
As far as I know, that's correct. It was just a question of occupancy by someone besides the tenant.
Tenants were physically still there, and then Miss
Penland passed away.
Weren't there also a number of years before the property was actually rented?
There were a number of years when the property was basically not occupied by anyone. From the time, I think 2010 until 2012, she was, I think she moved out of the house somewhere around 2010, and from 2010 to June of 2012, it was unoccupied. Or if it was occupied, it was occupied by the daughter when she'd come down from out of state to visit her mom.
Does that fact have any bearing on your argument that basically renting the property equates to a waiver of the homestead protection or status?
Well, I think up until that point in time, and again, I'll be very clear about this, if they hadn't rented the property, I think it remained homestead. If they had not rented the property to a third party, it would have remained homestead.
So your argument is the rental of the property equates to the waiver of the homestead?
In this case, yes. And in most cases, that's true, at least if the homestead determination, if the ward passes away while that lease is basically in effect and third parties are occupying the property, because the ward cannot occupy the property. Part of the whole issue of the homestead protection is that you have occupancy, because it's basically your primary residence, or the ability to move back if you're out because of illness or health issues, just like we have in this case. But the critical question is...
But if we're talking about abandonment, that you have to have an intent to abandon the property, and you're saying that simply because they leased it, that constitutes an abandonment, is a matter of law, right?
Well, let's look at a couple...
Of course, you know, we have a ward that's been declared incompetent and a plenary guardianship appointed, but there was no indication that the ward wanted to abandon the property before she was removed and put into the nursing home, right?
Well, I don't think she wanted to abandon it prior to that time, clearly not.
So isn't there a difference between simply leasing a house that had homestead status by the owner of the property, and in a situation like this where a ward never indicated any intent to abandon the property, a plenary guardianship is appointed and she's removed to a nursing home where she can occupy the property, and the ward says, well, we have to do something with it. Instead of leaving it vacant, we're going to lease it. Isn't that a little bit different situation?
Well, I think the situation is, your focus is on the intent, but if you look at the case law, it's not just simply a matter of intention. You can say all day, I never intend to abandon, but you can take steps that your acts will basically nullify your claim of intention.
In this case, you're kind of forced into a situation because of old age and incompetence, and nobody ever really wanted to relinquish the homestead status, but you had to rent the property in order to get some income out of it, or just leave it vacant.
Well, here's the dilemma in this case, and again, I'm not sure the record is complete enough for the court to really pick up on this point, but she was qualified for Medicaid. Medicaid basically takes the position that a long-term rental basically abandons the homestead status. That's the Medicaid rule. You can basically establish by going to Medicaid and saying basically I'm not intending to abandon it, but those cases don't deal with a guardianship situation like we have here. So the question is whether or not the actions of the guardian, they have to make a determination in their mind, is it essential for me to basically give up the ward's homestead to be able to pay guardianship expenses?
You said before, if they had leased it, that would be the lease is kind of the determining factor here. What if the ward had just, the guardian just said, well, we'll just leave it vacant, nobody's living there, just left it vacant, then what?
As strange as it sounds, it would be protected. That's, as strange as it sounds, it would be protected.
That's kind of strange. I mean, because, you know, the guardian is put in the position where we'll lose the homestead status if we get some income out of it, and we put it to some use and rent it. But if we just leave it vacant and don't use it at all, we can maintain the homestead status.
Well, you can leave it vacant or have a family member there, or you could, you can have that issue, but
We seem to now be having two different sets of facts depending upon whether you have an incompetent owner or a competent owner, because clearly if I'm a competent owner, I move out of the homestead, I lease it, but without an intent to abandon it, I may come back years later, and then, a creditor may come in and say, well, I'm going to try to levy on my judgment against Lambert because that's not his homestead anymore. Then we'd have an evidentiary hearing of whether my leasing of the property and moving out for a limited period of time abandoned my homestead. Or we'd talk about my intent because I'd be competent to testify subject to cross.
I would agree.
And here we're saying, when you have a person who's been there for 31 years, then they become incapable of expressing their intent, that if his or her guardian makes a judgment call to say, I want to, generate some income so we can pay some of the bills, I'm going to lease this property, that fact in and of itself, assuming then the ward passes, is a dispositive fact. Well, because of what the guardian chose to do.
If you look at some of the guardianship cases, one judge specifically observed that debtors never admit they intend to abandon their homestead. So that's never going to be an admission on the part of a debtor in any case, whether it be this case or another case. The question, though, is whether or not, in the context of the ward who's got no ability to make that decision, does the guardian make that decision for her? And if the guardian can make that decision for her, and let's take the example that she sells the homestead. Are you saying that the ward never wanted to sell the homestead and therefore never gave up the rights to homestead status?
In the non-guardian scenario, then do you take those proceeds, reinvest it into another house with the intent?
If you did that.
Right.
But if you've got a situation here, so you have these situations where you have Medicaid, sort of the overlay here is, you have people that are qualified for Medicaid that are not incompetent. Okay, there's sort of two subsets here. The Medicaid issue is that if you rent the property that is your homestead, and you're a Medicaid-eligible person, which Ms. Penland was qualified for Medicaid, then you waive that homestead or that protection. You now have disqualified yourself from Medicaid status because you now have an asset that is available, a resource that's available that disqualifies you. Your homestead is exempt if it remains as homestead. If you rent it and it is no longer homestead, then it's now an available resource. That's the Medicaid issue. In this case, they have two problems. Number one, the income that they're receiving also disqualifies the ward from Medicaid eligibility because now she's got too much income. And so the only way they would have to qualify her for Medicaid and keep that income is to set up what we call a Miller Trust, which basically says we hit the cap for Medicaid purposes and all the income above that goes to the nursing home or goes back to the state of Florida. So renting the property really, if you're trying to stay within the Medicaid parameters, really doesn't accomplish anything. It doesn't basically create a lot of extra income for this particular ward because if she's getting, I think the income limit is $1,500 or something like that. She's renting this for $1,100 if her Social Security's, I don't know, $1,000 a month. For her to basically maintain her Medicaid status, she's going to have to basically put most of that back to the nursing home or the state of Florida's Medicaid fund. So that's the dilemma that you have here. So that's why our position is the guardian, by taking that position and saying, it's in the best interest of the ward for us to basically take that money and use it and therefore kick her off of Medicaid, that basically has the same effect of kicking her homestead exemption out because now it's an available resource. Medicaid treats it as an available resource, and now this court should treat it as an available resource, and we have guardianship expenses that were incurred that have never been paid.
Well, listening to your argument, that couldn't have possibly been in her best interest to do that.
Well, I didn't, I would agree with you. I'm not sure that it was. In fact, you didn't see the professional guardian petition to do that. I think she understood the rules of the game and understood that that was not a smart thing to do. This guardian stepped into it and said, oh, well, let's just rent it, without, I think, realizing what implications that had for her ward. And I think that's where the problem comes in.
Do you have any case law or authority to support that Medicaid argument, though? The Medicaid eligibility waiving the homestead status?
I don't have it in my brief, but, the Medicaid laws and the Medicaid rules are fairly clear. What you have to do, again, in the situation, as I understand it, is you basically have to file a declaration with Medicaid. If you're going to do something that would otherwise terminate your status, you would have to file a declaration that says, I'm not intending to abandon my homestead. I'm having to do this because of a medical reason or some other reason, and I'm going to rent it temporarily. But here you had a full one-year lease. It's not like a rental for a few months just while, something is needed for the ward. So again, I did not brief that, so I can't give you any citations to the Medicaid rules because they're fairly complex. With that, I'd like to reserve the rest of my time.
May I please the court, Brendan Tyson. I represent the appellee, Karen Moody Alchin, in her capacity as both personal representative of the estate and also in their individual capacity. Our position is that the guardian in this case does not have the authority and did not waive the homestead protections that were afforded to Ms. Penland. Their position is there's some sort of authority that would, and their claim is that it's implicit in 744-441, that by renting the homestead, that the guardian, in essence, waived the rights of the ward. Case law is clear that there can't be a waiver of homestead. Circumstances of this case are such that...
What if she petitioned to sell the property instead of leasing it, and sold it, got the money, and put it in the account, and just put it in the guardianship account, and it was sitting there? And then she passes, the ward passes, and then the guardian and the attorney for the guardian, the professional guardian, come in and say, okay, there's $100,000 there, we're owed money, we were appointed, we have the fees that have been awarded, and we'd like to get that money because clearly the homestead was abandoned, it was sold, and it was not reinvested in a new home.
Well, it's a different set of facts that are not applicable in this case, but just... in that situation, that would be probably, I don't want to use the word waiver of homestead because there's no such thing as a waiver of homestead. I think the court kind of got it right. There has to be abandonment of homestead. And so the question would be, okay, the guardian then sold the ward's property, the money's sitting in a bank account. What is that money for in that bank account? Because I think the trial court made it clear that when a person such as Ms. Penland goes into an assisted living facility, it's always a temporary situation, or at least the ward hopes it's a temporary situation. Guardianship is never designed to be permanent. So if the intention is to reinvest those proceeds, let's say perhaps in another homestead, because the ward has the right...
What if there's been no action taken to doing that because the guardian says, mom's going to end up having to stay here because she needs round-the-clock care. We're not going to buy her a smaller house. We're going to keep her here. We have those monies. It's sitting there, and then the ward abruptly passes, and then the money's there without any objective, overt action to try to reinvest the homestead proceeds. Haven't they then arguably lost the homestead protection and they're fair game to the properly filed creditors?
I think under your set of facts, you're talking about a permanency situation, a permanent situation. The case law says if a homestead is temporarily abandoned for purposes of health, infirmity, and whatnot, then you still maintain the home.
I understand, but your premise early on was that there was no way you couldn't... By filing a petition, the guardian can't waive certain constitutional protections of the ward because the 744 doesn't permit that. But in my hypothetical, you petition to sell the homestead property. That's what you title it. The judge grants that. The money is then put into account. It's not then, invested, in the non-guardianship, non-incompetent person. Then we have to talk about, were we intending to use it for another homestead and the money itself remains protected. Here, objectively, nothing happens to suggest that.
Under your hypothetical, I think it'd be facts and circumstances. If there was evidence before the trial court that the ward was going to be in the nursing home or ALF for a permanent period of time, then there's abandonment. I think there would be facts and circumstances to show abandonment. Then the trial court can say, yeah, you're right, Judge, the money's been sitting
So
under
then it can be, then under my hypothetical, filing a petition to sell as opposed to lease under the same statutory provisions of 744.441, that, there's no separate requirement of filing, and Judge, am I permitted to waive homestead or abandon the homestead? You file the petition, you sell it, boom, these are the facts that occur, there's no objective indication to reinvest the money in another homestead. They might have then lost the status of homestead-protected funds.
There might have been a showing of findings in that case of abandonment. I think that's the situation we're dealing in the circumstances of this case. And there's case law, and I'll cite to it, that basically says even temporary rental of a homestead under certain circumstances does not impose the status of abandonment, where the intent to return is present. Now, there's been no findings by the trial court that there was not an intent to return. In fact, the trial court judge sort of took the opposite position and said, hey, in all the cases that are before me, the ward always has the intent to go back. So I think the guardian has the right to keep that home available for the ward. And the facts and circumstances of this case, she lived there, as Judge Lambert said, 31 years, I believe. That was her home. And so I think the guardian has the right, the authority to keep that home in case she does come around. She was in an assisted living facility. She wasn't in a nursing home. She wasn't in hospice. There wasn't any facts or evidence before the trial court that this was a permanent situation. Her health may have turned around. She may have wanted to go back to her home. And I think, again, another point that the trial court brought out that was very important, and I think, Judge, you brought it up, was, okay, we just leave the house vacant. Now we've breached our duty to use the income and the resources to pay the bills of the ward. So if we just keep the house vacant, and this was an argument made by counsel in the lower court, that if we just leave the house vacant, don't do anything, we keep our homestead exemption. But if we rent it and do what I think there's a duty imposed upon the guardian to do, is let's use this asset for the benefit of the ward to pay our expenses and whatnot, now you've lost our constitutional protections. To me, I don't think that's a logical argument, and I think the trial court sort of harped his decision based upon that. I think, again, I kind of go back to the same point that in order for there to be abandonment, I'm citing the Barlow versus Barlow case, abandonment occurs when an owner removes from the home with no intention of returning, takes a permanent abode at another place, and pursues a livelihood there. So the case law shows that you could actually not even be living in the homestead and still get your homestead exemption. And the case...
Let's assume you had an evidentiary hearing on this, and the guardian was called to testify, and Mr. Wilkins says, well, was it ever your intent for your mother to go back and live in that home? And your guardian says, no, we were never going to put her back in that home. We had no intent to do that. She needed round-the-clock care. It was just impossible for her ever to go back. Would that not be evidence to suggest an abandonment of the homestead?
I think if the guardian testified that the ward had no intentions on going back, because remember...
How would that not be a hearsay statement?
It would be hearsay because it's a statement of intent. It would come under the hearsay exception. A statement of intent is an exception under the hearsay rules. I intend on going to the store today. That's not...
So your position is that it's not the intent of the ward, it's not the intent of the guardian, it's the intent of the ward, even though the ward has been declared incompetent?
Well, but the issue is a guardian only can act. That's why I think it goes back to the argument about whether a guardian's actually an agent and can step in the shoes. A guardian can. A guardian can only exercise those rights that have been adjudicated, taken away, in essence, from the ward.
Well, it's a plenary guardianship, so all the rights are taken away.
Well, not necessarily. I think she has the right to vote and certain things.
That is designated in the guardianship order as to what rights are retained.
Well, but she still has certain rights to, and I don't know the statute off the top of my head, but there's certain rights.
I was a judge for many years, so I mean, you check the boxes off.
Oh, I know what you're saying, but I think there's rights that are always retained to be safe and to have somebody manage your affairs appropriately, that your wishes are always taken into consideration. I believe there's a statute under the duty that all wards, even if they're even if it's a plenary guardianship, there's certain rights that are always retained by the ward to be treated appropriately, that the guardianship is always for the benefit of the ward. So I think we'd always have to take in the ward's considerations, because remember, it's the ward's property. It's not the guardian's property. The guardian just can't do what she wants at will.
Scenario, if the ward's in a coma, then basically whatever the guardian has to say about what the intent was or while we were doing this, it doesn't matter because the ward can't testify.
Well, but if the ward's in a vegetative state, actually, one of the cases that I cited actually talked about, I think it was I want to make sure I say the case correctly. One of the cases talked about a person was in a vegetative state. It was the issue of the rental property. The person was in a vegetative state, I believe, for 2 years. And in fact, under the circumstance, it's the Crane versus Putnam case that I cited in my brief. The person was placed in a nursing home, was in a nursing home for 2 years, was in a vegetative state, and the court said under those circumstances, she had not waived her homestead protections. Now, that case dealt with property tax, but what the court also said in that case was she wouldn't have lost her constitutional protections under Article 10. There's no reason why she would have lost her property tax exemption. So that was sort of a fact scenario similar to what Your Honor is bringing up. I think if you can't ascertain her intent because she's in a coma or in some sort of vegetative state, then I don't think you can make a finding of abandonment. I think in order to make a finding of abandonment, there must be affirmative facts and circumstances that show the ward has left her homestead and has no intention of, going back there. And I think that's really the positive issue.
But were there any findings made by the findings made by the trial court, did the trial court base its decision on its finding that the ward didn't intend to abandon, or that the guardian formed no intent to abandon, or was it both? I think it might have been both.
I think it might have been both. I think it might have been both. Like I said, I think the judge harped on the fact that, and I was there, so this was we have a transcript. I think the judge really focused his reasoning on the fact that wards, and especially people in assisted living facilities and nursing homes and of that nature, always want to go back. And there was no real evidence to suggest otherwise. And so I think the judge...
Let's say the guardian was, in your situation, the guardian's not the one who was going to get the homestead. Because obviously there's a vested interest in keeping the homestead because that's now going to be her property.
Yeah.
The ward tells the guardian, I want you to sell my home, I'm never going back there. And so the guardian says, I'm selling the home, or I'm leasing the home, or do whatever, I'm never going back. And then, Mr. Wilkins comes in, makes the claims, and the guardian says, the ward told me to sell it because she never wanted to go back to the home, or the ward told me to lease it because she never wanted to go back. And let's say that under the will, some other people are the inheritors of the homestead. Is that admissible evidence that the guardian is telling the ward, I heard the ward tell me this?
I think it's a statement of intent. I think it's the same situation that you discussed earlier, Your Honor. If the ward said to the guardian, I have no intention on going back, that's not my home anymore, I've come to the realization I'm going to be in this place for the rest of my life, and then there's some action to dispose of the property or rent the property, under those circumstances, yes, I think we'd have an express finding of abandonment. But under the facts and circumstances of this case, is the evidence, the record, we don't have that. We don't have that. Those are not the circumstances of this case. Circumstances of the case is the woman lived in her home for 31 years, was part of an involuntary guardianship proceeding, and was placed in an assisted living facility by her original guardian, the appellant, and then subsequently, I think, was moved to a couple other assisted living facilities by her daughter, who became the successor guardian. So that's the facts and circumstances of this case. And I think the central issue is a renting of a homestead, there's no case law, there's no statutory support that a rental of a homestead per se constitutes an abandonment. In fact, the case law kind of says to the contrary, that a temporary rental is not an abandonment. And the case law again says when you have to abandon your homestead, literally.
Let's assume we affirm your position. And what position does that place professional guardians and attorneys who represent professional guardians? Do they have to then get in a scenario saying, look, we're going to be incurring fees and costs, there's limited funds here, but there is a homestead. Before we get involved in trying to assist a ward who needs help, we need to understand that that homestead may be available to use to pay our expenses. I mean, is that now where we're going to force the negotiations or force the hands of people to do that? And I understand there's constitutional protection. You don't have to tell me about Article 4, Section, I understand all that, but, I mean, what's, the practical effect is these Mr. Wilkins' clients over here saying, we came in, we're professional guardians, we're attorneys, we're helping this lady, there wasn't anybody down here helping her, and now we're left holding the bag because we're just not going to get paid.
Well, but professional guardian is almost a situation like every attorney. When every attorney enters into a case, oftentimes they have to look at the money circumstances. When a client comes to me and, the circumstances, I know it's going to be a difficult case, and I know that there's going to be a lot of discovery, depositions, and things like that. Sometimes I say to a client, okay, it's going to cost you X amount of money. That affects my ability. I think it's just a common occurrence, and it's unfortunate, it's the reality, and it's a practical consequence of a guardian being in a situation where they're doing it for profit. It's just like lawyers. I mean, there's many cases that I think we all would love to represent, but just practically, we know if we get into it, we're not going to get paid probably what our time is, going to put into it. So I think a professional guardian's going to have to make the same decision that a lawyer. I mean, a lawyer and a guardian, in essence, both have fiduciary obligations. We both have standards, ethical standards that we have to impose on, and there's always cases where we'd love to help people and love to get involved, but we can't.
In this scenario, there's no ability for if the ward was competent, the ward may consent to this, but now in a scenario where the ward's not competent, if I'm going to be a professional guardian, professional ward to help this person, I have no way of negotiating, because even if I negotiate to say, well, will I be able to use the homestead to get the fees if it comes to that? You could come back as the attorney down the road and say, well, you know what? The ward I did not have the authority to waive the homestead protection of the ward, so therefore, I know I told you something before, but now that doesn't count.
But I think if a guardian's in a situation where they can't afford to get their fees, they're probably also in the situation where they can't afford to pay the ward's assisted living, costs. If the assisted living...
That's just being paid by Medicare, I mean, that...
Well, not assisted living, so those are not covered under the ICP program, which is the ICP program, the institutional care program, pays for the cost of nursing home, advanced skilled care. In this circumstances, Ms. Penland was living in ALF. She was living in an assisted living facility. In fact, the circumstances of this case were she was not on Medicaid, she wasn't getting Medicaid benefits. Her ALF was being paid by her assets and other sources of income. So if a guardian's in a situation where I got to pay the ALF, or I got to pay the doctors, or whoever they may be, that a guardian may make the decision under those circumstances to sell the homestead. And of course, they'd have to file a motion, go before the trial judge. So under your circumstances, if a guardian's in that situation, I need to get paid, I'm not going to take this case because there are no sources of funds, then the guardian can go to the trial judge and let the judge, under his authority, under 744, 4.441, decide, is it in the best interest of the ward to sell the homestead because the ward needs this guardian and the guardian can't get paid? In this case, there was a lot of liquid assets. The guardianship started off with over $270,000 in liquid assets, which were spent mostly to pay the guardian in this case. So this was not a case, as Your Honor brings up, where that was it, the house was it, there was really no other source.
Regarding the Medicaid eligibility argument that was
Yes.
raised, what is your opinion regarding the applicability or relevance to this issue?
I don't think it has any relevance, because whether she qualified for Medicaid, and again, there's no record evidence to support that she was qualified for Medicaid or that she was receiving Medicaid benefits. But taking it a step further, whether she qualified or didn't qualify has no bearing on her constitutional protected rights of homestead. And what I analogize that to is sort of what I argued before, is the homestead protections are kind of separate. I think there's 4 different homestead. You have tax exemption, and you have constitutional exemption from creditors. I think there's protections against alienation. Those are all distinct protections afforded to citizens of our state under homestead. So if you qualify under one, or you don't qualify under one, it doesn't necessarily mean you lose the other. They're trying to take another area of the law, the Medicaid area, and try to imply that that somehow has some direct correlation on the homestead. And in fact, our position is, even if she had this property and was renting it, I don't think that would disqualify her. And I've cited to some in my brief, some statutes, some of the parts of the administrative code, the Florida Administrative Code, that deals with qualifying for ICP benefits. Even assuming that their position is right and she was disqualified from Medicaid, how does that, there's no support to suggest that you lost your constitutional rights to homestead as far as creditor protection because now you don't qualify for a government benefit. There's just no...
Just to clarify, there was no evidentiary hearing, really. I mean, basically, the facts are kind of undisputed, right? And nobody really disagrees with any of the facts. And so the trial judge in this particular case just got the memos, heard arguments of the attorneys, and everybody agreed on the facts and made a decision, right?
That's absolutely correct, Your Honor. If there's no other questions at this point. Thank you.
Thank you.
Let me at least make the point that we do have a statute, and he's correct, we have homestead several places, homestead for taxes, homestead for creditor protection, et cetera, but there's absolutely a statute, 196.061, and if you look at the history of that statute, you will see that it becomes more and more homestead adverse, I'll say. It says right now, the rental of all or substantially all of the dwelling previously claimed to be a homestead for tax purposes shall constitute the abandonment of such dwelling as a homestead, and the abandonment continues until the dwelling is physically occupied by the owner. Now again, I understand that's in the tax area, but I think the concept that it's trying to point out is that...
Why didn't the guardian just petition, have the property sold and be done with it? Because really, I think if the property had been sold, that would have been it. I mean, the proceeds would have gone into the guardianship account, and that would have been it. That's clearly an instance where you sell the property to a third party and it is gone. There's no homestead then.
Well, I don't think there's anything in the record to suggest why they didn't do that. I think...
Is there anything that, is there anything in the record to show that the guardian couldn't have done that?
The guardian absolutely could have done that. Absolutely could have done that.
So the guardian elected to hold on to the property and just rent it and get the income from that instead?
That's right. And again, the question is whether she should have in fact sold it if the rental income was not going to be sufficient to pay for her expenses, including her guardianship expenses, should the guardian have petitioned to sell that property. The professional guardian had structured the affairs of this ward to qualify for Medicaid, and they had transferred the money into a pool trust. They had basically taken the steps to make sure that she would be...
If under the statute, the guardian can rent, the guardian can sell, the guardian can encumber with a mortgage, and if all those options were available to the guardian, yet the guardian elected to keep the property and just rent it out, couldn't that a judge look at that and say, well, there's some intent that they wanted to keep the property and not abandon the property as homestead, and maybe someday the ward could go back?
Well, I guess that's a question of fact. The question is whether or not the rental itself triggers the abandonment. And again, in the tax area, it clearly does. There's a statute right on point. So the question is that authoritative? The one thing I would point out, there's not a lot of law on this particular point. I'm delighted if this court renders an opinion on this, because I think the practitioners would love to see some bright-line test, if you will, going forward on this issue. But I think under the circumstances of this case, and you're right, Your Honor, there wasn't an evidentiary hearing. It was almost brought to the court, really almost like a summary judgment motion. No testimony about intent. The assumption was the ward didn't intend to abandon it because she lived there for 31 years, but I think the question is, did the guardian, by her actions, essentially terminate that homestead exemption? And again, the other thing I'd ask the court to look at too is that Marine Midland case, or the Midland case, where basically you have to cover the expenses of the guardianship before things transfer over to the probate side. So the question is, if the homestead terminated in the guardianship, then that asset stays in the guardianship until those expenses are paid, and those have not been paid to this point. So again, I think the interaction of the guardianship having the homestead or trying to preserve the homestead, again, I think the point is that if the bright line rule is going to be you can rent the homestead now and without fear of jeopardizing your homestead
I mean,
exemption.
I think that if a person is living in a home, let's say for 40 years, and decides that they don't want to live there anymore, or decides to go live somewhere else and they want to rent that property out, I think that's probably a much clearer case of abandonment and the attempt to abandon the homestead. But here you've got a ward that lived there for 31 years, and it was involuntarily placed in a guardianship, and then moved to an assisted, I thought it was a nursing home, assisted nursing living facility. That's a little bit different situation, I think. And then you've got a trial judge that heard all the uncontested facts as laid out by the parties, so there was no dispute about that, listened to the arguments, and then rendered his decision saying that the homestead status stays.
Well, again, I think this court reviews it on a de novo basis too, so.
And so you're saying that as a matter of law, we should just simply say that under these facts, because the property was rented as opposed to being sold, that's it, over and done with?
I think
In this case?
in this case, we believe that the homestead exemption was terminated when they rented and the ward died before it were retaking occupancy.
All right, okay.
Thank you.
Thank you very much.
Judge Sherry.